Hi, this is Stu Simone, and probate is a mysterious word to most people, mainly because it's related to death, a subject none of us want to talk about any more than absolutely necessary. But this is an important topic. For one thing, and I know we won't admit this, but all of us are going to pass away someday. And if there's real estate and any kind of monetary asset involved, you really want to watch this video because you really don't want to be involved in probate. In my mind, almost every probate is a tragic mistake, because probate can be entirely avoided in most cases. The best way is to have an attorney draw up a living trust package which contains a pour-over will. Living means that the trust can be changed or even revoked at any time by the trustee or trustees, which is usually you. You want a pour-over will so that any assets purchased after the trust was drafted and or not added to the trust are treated as if they are included in the trust. They're poured into it. Remember, here in California, and I believe all states, a will alone will not avoid probate. There is absolutely no reason not to have a living trust package, and it not only saves all the hassle and fees associated with probate, but it can have tax advantages as well. That's why I offer a standalone package for a living trust to anybody who asks for a very nominal fee. Now, after hearing what you're about to hear, you'll see why you want to avoid probate and have a living trust. Now, if a person with financial assets passed away without a living trust, somebody is going to have to step forward and offer to open a court case. If there is a will, then the person holding the will has a legal duty to open the probate and can be fined if they don't. I have seen situations where everyone in the family avoided this task, hoping it would just go away, and this eventually led to disastrous results, including foreclosure or loss of property, family feuds, and fraud. The assets are high enough, as of 2020 it's $166,000 in California, that this custodian of the will should hire a qualified probate attorney who has to file a probate case on behalf of this person in the estate of the deceased. By the way, just like people tend to hire Aunt Martha to be their real estate agent, even though she hasn't closed a deal in 5 years, please do not hire an attorney that does not have at least a half dozen probate cases currently pending. I know, I hired myself, and while I filed 250 bankruptcies and have filed over 100 lawsuits, I found that probate court is a very unique place with its own special rules. You want a bona fide probate attorney. Okay, first let's answer the questions. What is probate? Probate means that there is a court case that deals with transferring the property of someone who has died to the heirs or beneficiaries, deciding if a will is valid, and taking care of the financial responsibilities of the person who died. In a probate case, an executor, if there is a will, or an administrator, if there is no will, is appointed by the court as personal representative to collect the assets, pay the debts and expenses, and then distribute the remainder of the estate to the beneficiaries, those who have the legal right to inherit, all under the supervision of the court. The entire case can take between 9 to 2 years in Southern California, maybe even longer. Besides that, the filing fees will be over $930, and the attorney fees will be in the thousands, if not tens of thousands of dollars. There is a statutory fee scheme here in California based on the value of the probate estate. Both the attorney and the personal representative are entitled to a fairly large portion of the estate, meaning if you did not have a living trust with pour-over will, the heirs could receive less than they could have. So what are the probate attorney statutory fees in California? Well, the probate fees, i.e. the attorney's fees and personal representative's fees, are set by the California Probate Code. Statutory fees prescribed by Section 10810 are based on the value of the estate as determined during the probate process. The value of the estate is generally determined by an inventory conducted by the estate's executor and sometimes with the assistance of appraisers designated by the court and a probate referee. Unfortunately, in making the valuation, the court does not consider the debts of the estate to offset the gross valuation, and thus determines the fees based upon just the gross valuation of the assets in probate. All right, what does that mean? For example, if a house is appraised at $500,000 but it has a mortgage with a $300,000 balance, the house is still valued at $500,000 for the purposes of calculating the probate fees. So statutory probate fees under Code 10810 are as follows: 4% of the first $100,000, 3% of the next $100,000, 2% of the next $800,000, 1% of the next $9 million, and 0.5% of the next $15 million. Now note that the above referenced calculations may have to be done twice, once to calculate the attorney's fee and the other to calculate the personal representative statutory fee. So you double those percentage amounts shown above. Remember, the best thing is to avoid paying these fees by creating a living trust with pour-over will. All right, that's pretty depressing, but the good news is you don't always need to file a full-blown probate case. Here are some situations where a full case can be avoided. 1, there's a living trust with pour-over will. The trust was funded and the pour-over will is properly drafted and does its job of pouring over any new assets that were not named in the trust. And the family does not need to go to court at all, as there's no need for court interference. That's great. How about number 2? The property was deeded out of the living trust, usually for the purposes of a refi, but not transferred back to the living trust. Well, have no fear. Your probate attorney can file what is known in California as a Hegstad petition, which should not take more than 3 months to accomplish. Number 3, a couple has been married many years, but the property title is on one name only, and that spouse passes away. If the property is considered community property, in other words, acquired during the marriage but not inherited, then this spousal property petition case should only last 2 to 4 months. Number 4, there is unimproved land worth less than $55,425. The court will appoint a probate referee to assign the value of the land, resulting in an affidavit of real property of small value. Property is worth between $55,425 and $166,250. Then a petition to determine succession to real property is filed, where the referee determines the value and the judge determines who gets what. Number 5, the total value of the probate estate is $166,250 or less as of 2020. This is considered a streamlined probate case and should cost about $2,500. So here are the steps in a full probate court case. 1, determine the executor administrator. If there is a will, then the custodian of the will must take the original will to the probate court clerk's office within 30 days, send a copy of the will to the executor. If the executor cannot be found, then the will can be sent to a person named in the will as a beneficiary. If the custodian does not do these things, he or she can be sued for damages caused. If there is no will and a court case is needed, the person who wants to be the administrator must file a petition for letters of administration. The administrator usually is the spouse, domestic partner, or close relative of the dead person. The probate court will appoint an administrator to manage the estate during the probate process. At this point, the personal representative, the executor, if there is a will, or the administrator, if there's no will, should shop for attorneys and bring as many heirs as possible to meet with a top choice. The distribution of the estate should be discussed, which usually includes real estate. Sometimes a realtor is brought in at this time as well to help with the process. Step 2, you file a petition for probate. Someone called the petitioner must start the case in court by filing a petition for probate. That's California Form DE 111. The case must be filed in the county where the person who died lived most recently, or if the person lived outside California, in the California county where that person owned property. It's very important to know that a probate course requires more forms than just the probate petition form. For example, a very important part of the petition regarding real estate is whether the personal representative is to have full authority or limited authority under the IAEA, the Independent Administration of Estates Act. That's a series of laws allowing the personal representative to administer most aspects of the decedent's estate without court supervision, including the sale of real estate. It is a bad idea for a petitioner to try to draft and file a probate petition. Hire an attorney for this. Step 3, you administer the probate court case. The probate attorney should handle the actual court case, but it's important to know that if the personal representative does have full authority under the IAEA, he or she can file a Notice of Proposed Action, a NOPA, and sell the decedent's home and other property in as little as 15 days. Typically, the representative will shop for and hire a real estate agent at this time. On the other hand, if the representative only is given limited authority, then the court is much more involved and the process of selling the property is far more complex. I'm not even going to get into that here, but suffice to say, there are a lot of rules, including an overbidding process in court. There's motions, and the judge has to approve everything that is done regarding the estate. And even with full authority, there's a lot to be done in the court case. So trust me, this is the kind of process best handled by an experienced probate attorney, someone who does probate on a regular basis. Okay, takeaways. This is no time to cut corners. These cases are backlogged in the California court system and can take a long time, and a personal representative to try to do it alone risks having the entire case dismissed. Instead, if you find yourself as custodian of the will or personal representative, select a probate team consisting of a trusted probate attorney and a probate realtor. A good probate realtor will do more than pay for himself by formulating the best fixing up, marketing, and selling strategy, and can save problems in the transaction by understanding the probate laws. So hopefully this has given you a little taste of what probate is and what it is not. This is regarding the state of California here. It's state law, so if you're in a different state, it will be a little different. But in general, you want to make sure that if you are the custodian of the will, or you need to file right away, get the process started. Don't think this is going to go away. When I was working in my law firm over the past decade, I can't tell you how many cases came in, and it cost them sometimes tens of thousands of dollars to unravel a case where they should have gone to probate and they didn't, and then years later they want to sell the property or something happens, and guess what? It is a huge mess. So hopefully this video has helped you, and keep watching right here at the Rock Real Estate YouTube channel.